Good morning, class. This is Mr. Stewart, and this is going to be the Chapter 2 integrity video for CRJ 130, Intro to Law and Judicial Process. A couple things before we get started in the material this morning is I did mark attendance for those people who had not submitted any graded work, and the introduction discussion did not consist that did not count toward graded work. So if I did mark that as of about middle of the day on Monday. If you have gotten graded work submitted since then, check your My Calhoun to see if you've been dropped from the course, and if you have, make sure you get a reinstatement form submitted to me, and I will be happy to sign that, saying that you are working in the course and you can continue. Other than that, I just want to draw your attention to the fact that Chapter 2 is a lengthy chapter. It has a lot of material in it, and there's no way in just 15 or 20 minutes in this integrity video that I can go over every single thing that's in Chapter 2. I am going to kind of hit the highlights and try to explain a couple of things to help clear the mud, so to speak, but that you have got to read these chapters in this textbook in order to understand this material. This is reading the chapters in this book in an online class is much more important versus an actual in-person class, because the in-person class you get 3 hours of lecture a week, whereas you get me about 15 or 20 minutes a week, and so there's no way I can cover the material. So what I'm going to try to do in regard to Chapter 2 is kind of go over the main parts, the things that I want to draw your attention to, and then you still have to get in there, and you're still going to have to read the chapters. Now, what I typically do in regard to discussion boards is I myself am usually a week behind on the discussion. So if you this week you will be discussing Chapter 2 in the discussion boards, I will start responding to that tomorrow, but typically it's the following week that I respond to your discussion posting. So make sure you go back in the previous weeks and see if I have asked you a question or responded to you in some way that requires some other response back from you, and make sure that you're staying in those discussion boards even after the week is over, to make sure that you're addressing what you need to address and answering any questions that I may have, because learning can still take place. Understand, this type of course, each chapter builds off one another, so even if you go back into a previous chapter, there's a possibility you could definitely learn something that could be helpful to you presently or in the future within the course. I'm also usually about a week to a week and a half behind on grading when you get something submitted. So it's usually a week to week and a half from submission until I get it graded, because that's just kind of the way the online courses flow. I do try to get everything graded in a timely manner, and then if anybody has any questions or problems about a grade you receive, make sure you reach out to me, and I'll be happy to explain to you why I evaluated you that way. And also, just remember, if you do have questions, problems, concerns, or issues, don't feel bad about calling me, about texting me, or coming by my office to see me if you're in the area. I'll be happy to assist you in whatever means necessary for the course, because I understand that sometimes in an online course, students feel like they're kind of on an island, and you don't have that classroom interaction. But at least I'm available to you via phone, via office hours, or whatnot. So make sure you reach out if you need help. Okay. Also, one last thing, make sure each week you're getting your weekly work submitted. That is posting a main answer to the discussion question in the discussion postings, going back a day or two later and posting at least 2 responses to others, and that you are getting that reflection paper done every week. And that reflection paper is really you telling me what you've learned and why you think it's important, or maybe even telling me something that surprised you, or whatever. It's your way of communicating to me that, hey, I'm grasping the material, I'm seeing what's going on here, and I'm learning from it. Okay, Chapter 2. Chapter 2 is, again, a lengthy chapter, has a lot of material in it in regard to the law and legal systems. And so it really spells out almost every aspect of the law and legal systems as we know it here in the United States, along with some background information on law and legal systems in other countries and in past historical times as well. It's important for us to understand what the term law means. And you would think that on the surface, defining law would be pretty easy. However, it's not, because everybody has their own perspective on what the law is, or what the definition of law is, and because of that, it's actually fairly elusive to determine, and pin down the definition of law. Now, the best definition I can give you is also the same one that's in your textbook, and it's pretty good. It says, law is a body of rules enacted by public officials in a legitimate manner and backed by the force of the state. Law is simply a set of rules. But it's more than just a set of rules. It's also a system for the enforcement of the rules, and it's also a system for the interpretation of the rules, and it's also a system for punishing those who violate the rules. And let's go back to that definition for just a minute. A body of rules enacted by public officials in a legitimate manner and backed by the force of the state. There's two key elements to that definition that are hugely important. One is enacted by public officials in a legitimate manner. We here in the United States, we have a set procedure for how we enact laws, and it typically goes through our lawmakers. If it's at the federal level, it goes through Congress. Congress has to pass a law, and then it goes to the president to be signed. What seems to be getting confused in our country right now, even by our own president, is the fact that he can write an executive order and people will jump and scramble and they feel like they must follow it as if it is a law. Guys, you do not have to go by any executive order issued by the President of the United States, because that is not a valid law passed by Congress. It is simply an order given by an administrator. It's not law. It's really a very strong suggestion to do something, but it's not law. It can't be law unless it follows the manner prescribed by the law to get made into law, and that basically uses that legitimate manner definition of what the law is. And it also has to be backed by the force of the state, and that means that if the law is made legitimately, it still has to be made by those who have the ability and the authority and the power to make the law. And how do we assign that? We typically elect our lawmakers. We don't appoint lawmakers, we elect them in this country. That's what makes us a constitutional republic, and many people call us a democracy or democratic society. We're actually a constitutional republic because we use the Constitution as the basis for our law here in the United States. And the Constitution spells out all of those processes for how law is made. So that should give you a little bit of an idea about what the law is. It's rules enacted in a legitimate manner by people who have the authority to do so, is really the best way that we can define law. Understand that because law is enacted by public officials, it is connected with the government. You cannot, unfortunately, get politics out of the criminal justice system. You cannot get politics out of the legal system. That is kind of the nature of the beast. So it is connected with the government. And when we're talking about enacting law in a legitimate manner, as opposed to let's say a political coup in some third world country, and a military dictator takes over and just says, here's what you're going to do. You're going to do this and going to do that. That would be law that would be enacted in an illegitimate manner. Or maybe law that was made by terrorists. That's illegitimate. It's not valid law, but yet people are afraid to even violate the law, no matter how it's written or who comes up with it. So understand that knowing what the law and the legal system is will carry you a long way in this course because once you understand what those systems are and how they work, everything just kind of fits into place. It's kind of like you just got to find the piece of the puzzle and plug it in the right location. Now we have two types of legal systems here in the United States. We have the criminal law and we have the civil law. Now the civil law is based on the idea that somebody can wrong someone else. And instead of arresting that person, instead of putting them in prison if one person wrongs another, we have the ability to use the court system to determine who was at fault and who was not, and then whoever is at fault will have to compensate the person they caused damage to, whether it was personal damages or property damages or simply some loss of face or status or notoriety or something like that. If you have suffered some type of loss at the hands of something that someone else has done, then you typically can sue that person in the civil court, and that's what we would consider a lawsuit. And the standard of proof is much lower in the civil law than it is in the criminal law. Basically, with the civil law, and hopefully you can see my hands here, with the civil law, all you got to do is tip the scales in favor of one side or the other. Whereas in the criminal law, you have to prove it beyond a reasonable doubt. You know, the scales are much more uneven in the criminal system than it is the civil system. So you don't go to jail for violations of the civil law. You simply seek a remedy, and it's a financial compensation type of remedy if somebody has wronged you. So you sue them, and then if you win, then they pay you money. Is basically the way it works. Now, from the criminal perspective, what we have is that is an actual violation of what we would consider to be the criminal code. And the criminal code or criminal law is rules that say these behaviors are acceptable or unacceptable within a society, and if you engage in the unacceptable behaviors, we will punish you for it. Punishment is kind of the key word to the criminal system. That if you violate the criminal law and you are convicted of that, you will be punished. And how do we punish? Typically, we put you in jail. We can also assess a fine. But just understand that it's punishment versus compensation. Civil law is about compensation. The criminal law is about punishment. Again, the standard of proof is much higher in the criminal case because we're going to remove some of your rights, at least temporarily, while we are punishing you, putting you in jail. So we have to be able to prove our case in a more strong fashion in the civil law. Now, your book goes on to describe socialist law, Islamic law, and common law as kind of some of the basic backgrounds of law where many countries actually develop and draw their legal system from. Socialist law is nothing more than communism. Understand that socialist law or communist law is about protecting the state and not about protecting the interests and rights of the citizens. And they also don't view law as a fundamental basis for society. The socialists don't. They basically view the law as basically the work of whoever is in power. And they enact laws that are not about right and wrong, but are about protecting their own interests. Basically, in socialism and communism, you have two classes of people. You have the ruling class and the working class. The ruling class has the power and the money. The working class doesn't. The ruling class wants to keep the power and the money. The working class wants to get some of the power and the money. So you have an innate conflict right off the bat because you have two classes of people who are competing against each other for the same pool of power and money, basically. So what you have is, because the ruling class are also the lawmaking class, they can enact laws that help them keep their power and the money. And it's not about right and wrong. It's just about us keeping what we have. So that's typically the way that socialism and communism and fascism works, is the fact that you have only two classes of people, and it's about a power differential. Who wants to keep the money and the power, and the laws are enacted as a way to do that. Um, Islamic law is also an interesting background for some countries because typically your Muslim countries law is based on Islamic law, and basically they don't remove religion from the legal system. At least in socialist law and in common law, which is what our system in the United States is based on, religion has been somewhat removed. In socialism, it's been all the way removed, but at least in common law, it's been somewhat removed to try to keep religion and the legal system separate. But in Islamic law, it's completely interwoven and interconnected with whatever their religious tenets are. So the judges undergo religious as well as legal training, and they mix and match their punishments between legal punishments and religious punishments for offenses. And some in the Islamic law, some of the offenses are offenses against the religion, some of them are offenses against the legal system. But the same legal system handles all of that. I think you can see a conflict of interest there. Lawyers under Islamic law also do not assert independence from the legal system or the government. They're part of the government machine, and juries are not allowed. Basically, you have one party that says, here's my decision, and it's not nearly as fair as some of the other legal systems are. And then that brings us into common law, and common law is really the basis of what our legal system is in the United States, and it comes from medieval England, where you had little counties called shires, and each little shire had their own set of kind of unwritten rules and regulations for being a citizen of that shire. Well, at some point, all of those unwritten rules and regulations kind of got collected and written down, and it became custom and tradition to do certain things with certain types of offenders. But it was based on fairness, and I think that's the important part. It was based on something that we call equity and due process, and what that means is just another way of saying fundamental fairness. It doesn't matter if you're charged with a criminal offense or not; everyone receives the same protection of the law, and everyone's rights are protected. And that's kind of where we are here in the United States right now. Is that all of our states' legal systems, with the exception of Louisiana, was based upon English common law, and Louisiana was based on Napoleonic Code or French provincial law. Again, it's a bit different from English law, but in the big scheme of things, it's still based upon the common law tradition, where we look at something called precedent. And what precedent is if we have a case now, and we can go back and find a previous case in history that used maybe similar facts and circumstances, we don't have to reinvent the wheel. We can use this, what's called the standard of precedent, which and there's a Latin term called stare decisis, STAREDECISIS, which means to stand by decided cases. And with using stare decisis, it means that we're gonna go back to that previous case, and that's going to help us make our decision in this case, so that we just don't have to reinvent the wheel. And that is one of the key characteristics of our system, is that we use the standard of precedent. We also see that judges have the ability to even change the law a little bit with some of their decisions. We would call that case law. That the judge may make a decision based upon the specific facts and circumstances in that case, and then that would set a precedent, and then we can go back and use that precedent later. And something else about our system is that it's an adversarial system. And what that means is, instead of an inquisitorial system, an inquisitorial system means it's one-sided. You have simply a fact finder who will extract the facts from the accused in any way necessary without worrying about protecting their rights. Whereas in the adversarial system, what we have here in the United States, you have two sides who are competing for the legal truth. They will both have the ability to present their side of the story to the court, and then it's up to the court to make a decision based on the credibility of the testimony and the credibility of the evidence as to whether that person should be found guilty or not guilty of that criminal offense. You don't win or lose a criminal case like you do a civil case. In a criminal case, you're found guilty or not guilty. We also, in the United States, do not find you innocent of a crime. Not guilty does not mean innocent. Not guilty simply means we did not have the required amount of proof necessary to convict you. And that's quite a bit of proof required under our system. We have to have better than 90% surety and proof positive that that person committed the crime before we can convict them of that crime. That's called proof beyond a reasonable doubt. And that's why I was giving you that scale a few minutes ago. In the civil case, you just have to tip the scales to one side or the other. In a criminal case, it's much more one-sided, proof beyond a reasonable doubt. So understand that the adversarial system is what makes our system of justice here in the United States unique, and it also is what provides that fundamental fairness and due process that everyone's rights are protected, including the accused. It's important that we protect the rights of the accused, because if we step on the rights of the accused, how long will it be before we step on the rights of the unaccused, the people who are law-abiding citizens, and then we begin to trample their rights and degrade their rights as well. So that's why it's important that the accused's rights are protected, is so that it really works out in favor of those who are not charged with a crime, to make sure that their rights are also protected. We can't trample on one person's rights and not trample on everyone's rights, if that makes any sense. We have multiple sources of the law here in the United States. First source is the constitutions. Every state has a constitution, and the federal government, the country, has a constitution that really set forth the basis of a lot of behaviors and some basic rights for its citizens. So the Constitution is one source of the law. We also have what we call state statutes or state law or state code. Those are laws that are designed and built by the lawmakers in the states or the Congress of the United States. They're the ones that come up with a law, develop a law, pass it, and then send it to the president or their respective governor to sign it into law. Now, the president and the governor can veto the law. If it goes back to the House or the Senate and gets voted on again, they actually can bypass the president's veto if they choose. Or if the law doesn't get signed within a certain amount of time, I think it automatically goes into effect because the president just doesn't sign it. Doesn't veto it or doesn't sign it, but it automatically would go into effect within a certain amount of time. So understand that state statutes are those laws passed by the state legislatures or U.S. Congress in regard to behaviors that we find unacceptable. We also see that administrative regulations are also made what we call administrative law. A good example of that would be the Environmental Protection Agency. What we see with them is that you have the director of the EPA that says, here are clean air and clean water regulations, and it allows them to prosecute criminally people who violate those regulations. That would endanger our air, our water, or whatever. That's a good example of administrative law. It's not something that's actually on the books that Congress has made, but it's a regulation that a department head has made to look after the safety and welfare of the citizenry, is really what administrative law is. Make sure in your chapter here that you read the section on judicial decisions, and that you know the difference between public and private law, the difference between civil and criminal law. Now, I want to talk for just a minute here about substantive law and procedural law. Substantive law is the part of the law that defines our rights. It also defines the crimes and what the punishments for those crimes are. It basically says, here's acceptable behavior, here's unacceptable behavior, and if you engage in the unacceptable behavior, here's what we can do to you, punishment-wise. Procedural law is simply the law that says here's how our legal system in this particular state or this particular country is going to operate. Here are the procedures that we're going to follow for a case to move through the justice system in that respective, whatever that respective political subdivision is. Also make sure that you know the difference between a felony and a misdemeanor. A misdemeanor is a less serious offense, typically carries a punishment of up to 11 months, 29 days in the county jail and a fine of less than $1,000, whereas a felony is a more serious offense. It carries a punishment over a year or more in prison and a fine of over $1,000. Also make sure on page 36 in your textbook that you familiarize yourself with the idea of due process or fundamental fairness. And I think that's all the high points that I want to cover with that. There's a lot of terms and there's a lot of concepts in Chapter 2. You may have to read it more than once to get everything you need to get out of it, but I think that understanding Chapter 2 is going to be the basis for you to be successful in the rest of the course. If you understand our basic concepts of law and how our system works, then we'll get into more detail further in the course of some of the idiosyncrasies of the law, some of the exceptions to the law, what it takes to meet the requirements of the law and elements of an offense and so forth. So remember, please read Chapter 2, and I'll see you guys next week. Remember, Monday is a holiday. That's Labor Day, so no work is required in the course on Monday, but I will be back in the office on Tuesday, and we'll get back to work then. Have a good week, guys, and I'll see you next week. Bye-bye.